Friends, we have been discussing about different types of business models in Indian industries. We have discussed about proprietorship firm, sole proprietorship and partnership, limited liability partnership, one person company and a private limited company and a public limited company. Apart from that, you can do business in many other business models. You can have a registration under the Charitable Societies Act, Travancore Cochin Charitable Literary and Charitable Societies Act of 1955, which envisages 7 or more persons can form an association under the Charitable Societies Act, and you can have a president, a secretary, a treasurer as the governing body members, and you can register under the Charitable Societies Act with the registrar under the Charitable Societies Act. When you talk about Charitable Societies Act, it is another model, business model. Say for example, don't be under the impression Charitable Societies Act is a small establishment. You look at the Regional Cancer Center Trivandrum, which is a charitable society registered under the Charitable Societies Act. The difference is there the Charitable Societies Act where the major share of the society is held by the government of Kerala. So that is what we call it as a government society. You look at Mada Amritavanandamaya Charitable Society, it is also a society. Another society is so when I talk about the society under the Charitable Societies Act, you can start with a small society to a very big society having turnover of crores of rupees like Mata Amritavanandamaya Charitable Trust or Shantagiri Charitable Trust. The purpose of the charitable trust is you have an outlook when you start a business. Why registering under the Charitable Societies Act is a very simple procedure. Now it is an online registration process under the state government. But only you have registered under the Charitable Societies Act, that doesn't mean you will get an exemption under the Income Tax Act. The Income Tax Act provides that under Section 12A, you will have to prove before the Income Tax Authority that your major source of income and expenditure are carried out or spent for the charitable purpose. Then Income Tax Authority will give an exemption, and under Section 80G, you can claim exemption from the income tax. So it is not, you cannot take it for granted. Once the registration under the Charitable Societies Act is obtained, you can get an exemption and you can treat it as a charitable society. You can treat it as a charitable society, but you don't get a benefit under the income tax unless the authority is convinced that your major source of expenditure and income is for the purpose of charity. Then comes the trust. Indian Trust Act governs. 2 persons can form a trust. So most of the temples are under the trust, under the Indian Trust Act. The trustee is a person. After the death of one person, the trustee or the legal heir takes over. That is under the Indian Trust Act that comes into operation. Again, there is another model of business operation that is called the society under the Societies Act. I am talking about the charitable society, which is different from the society which I am right now telling about. That is a Central Act of 1860, Societies Act, and Kerala government has formed a separate legislation, 1969 Kerala Cooperative Societies Act, where you can get a registration. The registrar of the cooperative society is the registering authority under the Act. So that is another model, business model. So both the society under the Societies Act, the charitable society under the Charitable Societies Act, we call most of the NGOs as charitable establishments. Because when you register an NGO, the process is very easy and you call it as NGO. These NGOs are registered in the Charitable Societies Act. So whether you are having any kind of business model as we have explained, the labor statutes apply on its own force and vigor when you employ a specific number of employees to operate different legislation. All these business models, when you employ 10 or more employees, ESI Act applies. 20 or more employees, Provident Fund Act applies. 10 or more employees, Payment of Gratuity Act applies. 20 or more employees, the Payment of Bonus Act applies. So these are all different models and the labor statutes apply on its own force and vigor based on the specification, definitions, provisions under the various labor statutes. So the tendency of all business people, business starter is, when you start a business, you tend to register an establishment either under the sole proprietorship firm or a partnership firm or an LLP or a private limited company or a public limited company or an one-person company or a Section 88 company under the Companies Act. The basic fundamental difference is when you are registering under the Companies Act, your liability as a director or a partner of the LLP, it is only limited to the assets of the company, whereas in the case of partnership and sole proprietorship firm, when any liability arises for the company, in the case of debt or anything from the in the case of repayment to the loans or repayment to the creditors, etc., your liability is limited to the assets of the company. That is why company is registered, all these companies. When I use the word company, it doesn't mean company under the private limited company or public limited. It also includes LLP, one-person company, and Section 8 company, etc. Whereas when you start a company as a proprietorship firm or when you start a business as a partnership firm, your risk is very, very high because your business collapses and your bank account, your bank people will come and attach not only the assets of the company, the bank people can attach your personal asset which has nothing to do with the business. So that is why when you start a business, people will think of having more security so that if at all the business something happens, collapse, the liability is limited to the assets of the company. That is why the term is used, private limited, limited to the assets of the company. Public limited company, liability is limited. Same way the liability is limited to Section 8 company, various foundation companies, and limited liability partnership firm, LLP. When you use the word limited liability partnership, you think it is a partnership firm. No, it is a limited liability partnership registered under the Indian Companies Act. Registered under the Indian Companies Act under the Ministry of Company Affairs. One-person company is also a company registered under the Companies Act. It is an amendment of amendment of the Companies Act of 2013. So all of us should be aware when you start a company, when you are going to start a company, the advantages of registering a company under the various categories or various business models. I hope these are the outline of the advantages of starting a business model in an Indian industry. Thank you very much.